Again, 1900 Territorial Act is a municipal law of the United States. Oh, let me go back. So, the territory of Hawaii, remember I said it used to be the Republic? It's specifically stated here that the phrase, the laws of Hawaii, as used in this act without qualifying words, shall mean the Constitution and laws of the Republic of Hawaii. So that's a direct link to the Republic. Now the Republic was not a part of the United States. The Republic was formed in 1894, okay, July 3rd. That's when it was formed. It was formed in Hawaii, not in the United States. And it was not a government. It was actually an installed insurgency by the United States diplomat. This Republic of Hawaii used to be called the Provisional Government. And they were formed on January 17, 1893. And the Provisional Government was an insurgency. Now that term insurgency is important because insurgency is a clear indicator that you're not a government, right? Because if you're an insurgent, you're in a revolt. You have to succeed and become a de facto government. But if you're still an insurgency, like George Washington was before 1783, he wasn't a government, he was an insurgent. But after King George III recognized the 13 former colonies as 13 independent states in a confederation, then they became a de facto government, recognized by the Great Britain. Okay? Now, how do we know anything about what happened in 1893, which formed the Provisional Government? Well, an indication for people who didn't know their Hawaiian their history, because we didn't know our history, because it wasn't being taught until now. Well, not now, but I would say within the last 20 to 30 years. So my dad, he wouldn't know. But when you had a joint resolution to acknowledge the 100th anniversary of the January 17th overthrow of the Kingdom of Hawaii and to offer an apology, that's when I went, oh, that's where the Provisional Government came from. Because the Provisional Government is actually in this resolution. Okay. The problem is that resolution is also a municipal law of the United States created by Congress. Okay, so that's kind of a basic timeline, right? But what is crucial here is how did the Republic of Hawaii, which was outside of the United States, become a part of the United States in order for Congress to make that name change? So, 1993 Apology Resolution, 1959 Statehood Act, and the Territory Act are all municipal laws. Municipal laws are defined to only apply to within the state. Before United States municipal laws, these laws have any effect outside the United States, meaning in Hawaii, you're supposed to have a treaty that it was incorporated in, right? So this is what we call annexation. Annexation is when a foreign territory is ceded into a state. Okay? And that process of ceding is what international law calls cession. An agreement between two entities where one entity is going to transfer to another entity, another state, territorial sovereignty. So cession of territory is the transfer of sovereignty over state territory by the owner state to another state. And the only form in which a cession can be effected is through an agreement. So here we have two sovereign entities under international law, two countries, they have their own governments. One will cede territory to the other, either voluntary or involuntary. And it's called conquest. So voluntary cession only takes place during what is called a state of peace between countries. An involuntary cession will only take place during a state of war. Okay? So examples of cessions that the United States received territory during a state of peace would be 1803 Louisiana Purchase. There was no war between France and the United States. There was negotiations to purchase that territory. Okay. And then during peacetime, they negotiated the Spanish Treaty of 1819, acquiring what we know today as Florida. And then during peacetime, state of peace, the Pacific Northwest, 1846, British Treaty. Now, all this territory here was all Mexican territory, belonging to the Mexican state. As a result of a state of war and a treaty of peace, the Treaty of Guadalupe Hidalgo is when those territories were transferred. Okay, so that's an example of conquest through treaty. What we have to do is keep that in mind when we're thinking about the Republic of Hawaii. Was it acquired voluntarily or by conquest? Either way, you need a treaty. So what we have here as far as annexation, we have Joint Resolution number 55. Joint resolution to provide for annexing the Hawaiian Islands to the United States. The problem here is this is a municipal law. It is not a treaty. It's one country saying, I have another country. But if it's a municipal law, you might run into some problems here because it's not mutual. It's not bilateral. Right? It's unilateral. Clearly, a joint resolution is not a treaty, no matter how you put lipstick on it. Yeah? It still looks like a pig, right? Well, from the 1898 congressional records, when they're debating this so-called joint resolution of annexation, Representative Thomas Ball from Texas says, the annexation of Hawaii by joint resolution, which is an agreement between the House and Senate, is unconstitutional, unnecessary, and unwise. The territory could only be constitutionally acquired by a treaty. So obviously he knows how the game is played. And then Senator Augustus Bacon from Georgia, he's on the record, and he's not the only two, there's a whole bunch of them. Senator Pettigrew, all of them. He stated, Senator Bacon stated that the annexation of foreign territory was necessarily and essentially the subject matter of a treaty, and that it could not be accomplished legally and constitutionally by a statute or a joint resolution, meaning by municipal law. You can't do it, even though we're about to do it. That's what he's saying. Well, the U.S. Supreme Court, what they say about municipal laws or U.S. laws, it says that, look, the laws of no nation can justly extend beyond its own territories. They can have no force to control the sovereignty of any other nation. That's what the Supreme Court said in 1824. And that's what other countries say as well, because that's international law. You cannot go past your jurisdiction. And then in 1936, Supreme Court reiterated the fact and said, neither the Constitution nor the laws passed in pursuant of it have any force in foreign territory. So even though they passed the law, it doesn't have any force outside of the United States. Everybody knew that. And then they go on to say, the Supreme Court, and operations of the nation called the United States in such territory must be governed by treaties, international understandings and compacts, and the principles of international law. What people today have been using to interpret Hawaii's history is American law. Whether Uniform Commercial Code, whether State of Hawaii Constitution, whether the U.S. Constitution, whether the federal statutes, all of that is American law, which according to the U.S. Supreme Court is limited to U.S. territory. So that's what has been adding to the confusion in this tribalism throughout Hawaii. Everybody's taking a different view. You're supposed to be looking at it through treaties, international understandings and compacts, and principles of international law. And people don't know what is international law. They confuse it. Well, in poli-sci, international relations is based upon international law and the relationship between states, which has its politics in and of itself, separate from the politics of domestic laws, right? International relations is a completely different animal. Very different. Very different. And here's the visual to show that U.S. laws are limited to U.S. territory. There's Washington, D.C., where the Congress is at. You got borders. U.S. laws have no force and effect beyond the borders of the United States. So the Uniform Commercial Code has no effect in Mexico. Then the Mexican Commercial Code has effect in America. It ends at the border, right? The Canadian Constitution has no effect in America. The American Constitution has no effect in Canada because of jurisdiction, right? So if you're going to be in Canada, you got to use Canadian law. If you're in America, you use American law. If you're going to try to talk between Canada and America, then you have to talk international law. That's different. Now, 90 years later, from 1898, in 1988, the U.S. Department of Justice stumbled over this quagmire, right? And they referred to that joint resolution of annexation, despite the constitutional objections by Senator Augustus Bacon, Representative Thomas Ball from Texas. Congress approved the joint resolution, and President McKinley signed the measure in 1898. Nevertheless, whether this action demonstrates the constitutional power of Congress to acquire territory is certainly questionable. It is therefore unclear which constitutional power Congress exercised when it acquired Hawaii by a joint resolution. That's pretty much upfront, to the point. They don't know how Hawaii became a part of the United States. So according to the Department of Justice, Office of Legal Counsel, if it was unclear which constitutional power Congress exercised when it acquired Hawaii by joint resolution, then it would be equally unclear as to how the United States created the territory of Hawaii and the state of Hawaii and the Apology Resolution, where it's riddled with misinformation called self-determination, indigenous people, all of that is wrong. But it's all American law. Anyway, it doesn't matter what it says, because it only applies to U.S. territory. But everybody gets caught in that American web, because that's all we knew. Right? That's all we knew. So then what is the legal status of Hawaii? Now, you got to keep in mind, though, remember what the Hawaii Supreme Court said. Regardless of its lawfulness of its origins, it is now a lawful government. Can you see how problematic it's going to get when you engage in the evidence? And the best thing that the Supreme Court can do is don't let the evidence in, because we will implode. Well, according to the Permanent Court of Arbitration in Larson versus Hawaiian Kingdom, which is an international court case, it says in the 19th century, the Hawaiian Kingdom existed as an independent state recognized as such by the United States, Great Britain, and other states. So the term independent is a term that we use wrong today. I always hear people saying we're trying to restore our independence. You guys heard that, right? Want to restore our independence. Well, what is it that you are trying to restore, right? An independent state. So we're trying to restore an independent state, right? Well, what is independence? Okay? A lot of times independence, the way we've been led to believe what it is we are already a part of the United States, that's the assumption, and we want to pursue independence. We want to be independent. Well, then what is independent? Independent breaking away? Actually, independent is a political term. It's not a verb, right? It's not independence, right? Independent is political, and it refers to a state. Because you can be a state and not be independent. State of New York, okay, that's a state, right? You also have states within Mexico. I think Chihuahua is a state. Yeah, is it? I think so. Yeah, because it's actually the United States of Mexico. That's its full name. It's a federation. So the determining factor of whether or not a state is independent or not is whether or not there is more than one law applied within that territory. So in Great Britain, it's an independent state. What that means is only British law applies over British territory. There is no other law. But if you go to New York, there are two different laws that apply within New York territory. There's New York law passed by New York legislature, and what other law applies in New York? Federal law. laws passed in Washington, D.C., outside of New York. So what you have there is a duality of laws, not a singular sense of law. Okay? So that's why the state of New York is not an independent state, but the United States, under international law, is independent because all you have is U.S. law. That is made up of state law, ordinances, maybe federal Indian law, whatever the case may be, right? But you won't find any other law in the United States from another state, because the United States is an independent state, but New York isn't, okay? So when people say to restore our independence, we have to identify what does that mean. So when, in 1843, the United States recognized in Great Britain the independence of the Hawaiian Kingdom, what that means is the United States acknowledged that Hawaii had its own laws over its territory, and that any American citizen who is in Hawaii is subject to Hawaiian Kingdom law. And any Hawaiian subject in America is subject to American law, which could be the Uniform Commercial Code, which could be the Admiralty law, which could be the constitutional law, whatever it is in America, right? And when Great Britain recognized the Hawaiian Kingdom as an independent state, it's also saying British subjects cannot claim protection under British law while you're in Hawaii, and conversely, Hawaiian subjects cannot claim protection under Hawaiian law in Great Britain. That's what independent means. Okay? So we got to get that out of our vocabulary by people saying I'm part of an independence movement. That doesn't make sense, given Hawaii's history, because the question is whether or not the state, which is independent, does that still exist? Because if that state still exists, right, then independence is a non-issue, because it's tied directly to that state. Make sense? Okay. In 1893, there were only 44 independent states in what was called the Family of Nations. 1945, when the United Nations was formed, there was only 46. Today, there are about 197 states. Not all are members of the United Nations. 193 are in the United Nations, others are not. So Cook Islands is an independent state in a confederation, well, actually protectorate status with New Zealand, okay? But it's still an independent state, and they made its choice to work with New Zealand, to have New Zealand deal with its foreign relations, okay? Now, imagine the Hawaiian Kingdom, we were part of 44, only 44. The majority of states that stemmed from the 46, which ultimately became 197, they all exercised what is called self-determination. That's when they broke away from the states. Like the United States, as a colony, as 13 colonies, exercised their view of self-determination by revolting and succeeding. So these are what is called successor states. Okay. Now, when people keep saying that we're part of the United States and we need to seek independence, what you're saying is we need to exercise self-determination because we're part of the United States. We've got to break away. That is completely false, and you'll see. Right? So again, we're clarifying the history. So we have to understand what happened to the state. Is it or does it exist? Well, we know it did exist, right? 19th century, Permanent Court of Arbitration said it exists. It exists, it does. But how does then that apply to Hawaii under international law, not American law? So Professor Greenwood, a former judge of the International Court of Justice, says traditional international law was based on a rigid distinction between a state of peace and a state of war. Countries were either in a state of peace or in a state of war. There was no intermediate stage. And there are certain terms, or not terms, certain actions that would trigger state of war from a state of peace. Now, international law is separated into peace and war. So, Lasse Oppenheim, renowned jurist on international law, Volume 1, peace. Then he has Volume 2, war and neutrality. This is state of peace, state of war. And there are certain rules that would apply during this state of affairs as would not apply during this state of affairs. That's what's important, okay? So whenever you hear the word neutrality of a state, neutrality only kicks in during war. Neutrality does not kick in during peace. It is triggered through war, like Switzerland. Belgium, Luxembourg. And the Hawaiian Kingdom was recognized as a neutral state in its treaty. So during war, you can't touch the Hawaiian Kingdom. Once in a state of war, the law of peace ceased to apply between the two states, and the relations with one another became subject to the laws of war. While the relations with other states not parties to the conflict became governed by neutrality, which basically meant that if there's a state of war between one or more states, any other state that is not part of the war have to be neutral. They can't pick a side. And they got to let these guys resolve their dispute. And war is legal under international law. It's just that it's regulated. And if an armed conflict occurs, the law of armed conflict must be applied from the beginning until the end, when the law of peace resumes in full effect. So again, just reiterating the two state of affairs. You guys following me with this? Okay. So now let's take a look at what happened in Hawaii, and we use President Cleveland's conclusions, because when President Cleveland speaks, he's speaking on behalf of the United States, because he is the sole representative of the United States as an office in international relations. The Congress can't speak under international law. The courts can't speak under international law, but the president can. And his statements are what is called dispositive, meaning it's conclusive and binding and has consequences. That's why a lot of times they try to make sure the president doesn't say certain things. And if you notice with Trump going around, they're trying to get him to not say certain things that could trigger certain things, right? That's the whole point, because other countries can rely on that. And I think you're starting to see Russia is relying on what President Trump said in that meeting that nobody knows what was discussed. You guys saw it in the news, right? They're actually referring to that agreement that was made with the president. And that actually is binding under international law, until someone within the United States makes some kind of claim that he can't do that. Well, actually he can. It's called a sole executive agreement. He doesn't need approval from the Senate or authorization from Congress. But it can get a little sticky under U.S. constitutional law. And I think Trump is really testing that system. I mean, he's really testing it. So President Cleveland says, after his investigation, authorized by Queen Liliuokalani, on the 16th of January, 1893, between 4 and 5 o'clock in the afternoon, a detachment of Marines from the United States steamer Boston, the USS Boston, with 2 pieces of artillery, landed at Honolulu. The men, upwards of 160, were supplied with double cartridge belts filled with ammunition and with haversacks and canteens, and were accompanied by a hospital corps with stretchers and medical supplies. Now, obviously, they're not landing to cook marshmallows at Kapiolani Park. They're ready to engage, right? A little background about myself: I'm a retired captain from the Army, so I know when you're loaded with that, you're going in for a fight, right? That's what you're anticipating. But what the key is, this clearly looks hostile. Yeah? The key is, what does Cleveland say it is, right? Because he is the one that is conclusive, not us. But that's pretty much looks like an act of hostility. I would call it an act of war. President Cleveland says this military demonstration upon the soil of Honolulu was of itself an act of war. He just triggered it. He triggered the state of war. Okay? And that puts the Queen and the Hawaiian government in a different situation. And they got to be careful how they play this one. Okay? Which led to the Queen's surrender on January 17th. Now, surrender is not transferring the country. Remember, that's a treaty of peace. Surrender is what? Stopping hostilities. That's all it is, right? Japan surrendered in 1945. That did not end the state of war. Japan was occupied after that point from 1945 to 1952. 1952 is when the Treaty of Peace took in effect. The occupation came to an end, and certain territories were released from Japan, namely Korea, Formosa, which is known today as Taiwan, and a few other islands. That is a cession, or should I say, a release of territory. So she writes in her conditional surrender, I, Liliuokalani, by the grace of God and under the Constitution of the Hawaiian Kingdom, Queen. Now, this other point where you keep hearing the word Kingdom of Hawaii, that's another thing to not keep saying, because we're not the Kingdom of Hawaii. The Apology Resolution of 1993 says Kingdom of Hawaii. But everything in the Hawaiian Kingdom says it's the Hawaiian Kingdom, including the Queen in her surrender. Because the Kingdom of Hawaii is actually a separate entity. The Kingdom of Hawaii used to be a separate kingdom under King Kamehameha I, separate from the Kingdom of Maui under Kahekili, and the Kingdom of Kauai under Kaeo, the brother. Kamehameha consolidated these kingdoms into one kingdom, the Kingdom of the Hawaiian Islands, which came to be known as the Hawaiian Kingdom. Make sense? So that word, ko Hawaii pai aina, you ever heard that? The Hawaiian word, ko Hawaii pai aina? People don't realize what that actually means, because a lot of us don't speak the language anymore, because we weren't allowed to speak it, our parents and grandparents. Ko Hawaii pai aina. Okay, ko Hawaii pai aina means Hawaiian Islands, but more literally, ko Hawaii pai aina means, so the word ko is a possessive. Hawaii is the subject, right? So this subject possesses something. Pai aina are islands. So ko Hawaii pai aina is literally the islands that belong to Hawaii. That's what it means. Meaning the Kingdom of Hawaii. Kamehameha, Kanaiaupuni, the conqueror. Right? If Kaeo won and consolidated the islands, it will be called the Kauaian Islands. Ko Kauai pai aina. If it was Kahekili, it would be ko Maui pai aina. You guys see that? So we have to stop calling it Kingdom of Hawaii, because that's in the Apology Resolution, which is an American law that doesn't apply to Hawaii. So that's one of the fabrications in that law. So let's go and say what it is based upon what our kupuna said it was, Hawaiian Kingdom. So she is saying that she is queen under the Constitution of the Hawaiian Kingdom, and that she hereby solemnly protests against any and all acts done against myself and the constitutional government of the Hawaiian Kingdom by certain persons claiming to have established a provisional government. So she's making a point, there's something called the provisional government that wasn't here before, right? That I yield to the superior force of the United States. That's why it's a surrender. I yield. The term yield does not mean to grant. Yield is a temporary transfer. And what is she transferring? She's yielding her authority, right? She's an executive. That I yield to the superior force of the United States, whose minister plenipotentiary, which is an international word for ambassador, His Excellency John Stevens, has caused United States troops to be landed at Honolulu and declared that he would support the provisional government. So she's saying this thing is calling itself the provisional government, and your U.S. diplomat is recognizing it. Now, to avoid any collision of armed forces and perhaps the loss of life, remember state of war? I do this under protest and impelled by said force, yield my authority, not yield the country. Yield my authority until such time as the government of the United States shall, upon the facts being presented to it under the action of its representatives, and reinstate me in the authority which I claim as the constitutional sovereign of the Hawaiian Islands. So clearly, you see a distinction between the government and the state. She's saying she's removed from that position, but that authority is still there. She wants to be reinstated, right? Because Hawaii is a constitutional system. It's a written constitution that says what the monarch is, can do, can't do, and all that. And then President Cleveland goes on to tell Congress, this wrongful recognition by our minister placed the government of the Queen in a position of most perilous perplexity. On the one hand, she had the possession of the palace, of the barracks, and of the police station, and had at her command at least 500 fully armed men and several pieces of artillery. Indeed, the whole military force of her kingdom was on her side and at her disposal. In this state of things, if the Queen could have dealt with the insurgents alone, her course would have been plain and the result unmistakable. Insurgents. President Cleveland referred to them not as the provisional government. He called them insurgents. That is not a government. that is an insurrection. Those are high treason people, right? And if you get convicted for committing treason as an insurgent, you get executed and all your property is confiscated. So clearly there's a distinction here between what is the provisional government and the Hawaiian Kingdom government, as opposed to what is the Hawaiian Kingdom government and the insurgency. Sanford Dole and them, in our history, they've always been portrayed as American businessmen, overthrew the Queen. No, President Cleveland never referred to them as businessmen. He referred to them as insurgents. Then President Cleveland continues, but the United States had allied itself with her enemies. You see the terms that they're using? These are terms that you use in a state of war. This is not during a state of peace where you're talking negotiating things, right? That the United States had allied itself with the Hawaiian Kingdom's enemies, had recognized them as the true government of Hawaii, and had put her and her adherents in the position of opposition against lawful authority. She knew that she could not withstand the power of the United States, but she believed that she might safely turn, trust in its justice. So, what did President Cleveland refer to government? Remember de jure, de facto? He says the government of the Queen was undisputed and was both the de facto and the de jure government. The way he's using de facto here, in fact, not by revolution, just in fact. When our minister recognized the provisional government, however, the only basis upon which it rested was the fact that the Committee of Safety had, in the manner, declared it to exist. It was neither a government de facto nor de jure, a successful revolution or a lawful government. Now keep in mind, the Hawaii Supreme Court says whatever its origins, the state of Hawaii is the lawful government. You see how it's starting to fall apart? This evidence, that's what they don't want in the court, because it is just going to implode. President Cleveland continued to state on the following day, January 17th, by an act of war with the participation of diplomatic representatives of the United States and without authority of Congress, the government of a feeble, weak, but friendly and confiding people has been overthrown. That's a conclusion. So not only did an act of war occur with the invasion on January 16th, but the consequence of an act of war was where government was overthrown. Okay. That's state of war. It triggered state of war, an international law. The only way to transform a state of war to a state of peace, you need a treaty of peace. Problem is we don't have a treaty of peace. That's what we're running into. There is no treaty of peace. So what you would call it then, under a state of war, it's called occupation, military occupation. That's what it's called. U.S. laws do not apply within occupied territories. So, an illegal war, because remember he said it was an unjust, this is illegal, we got to fix the problem. Well, an illegal war is a war of aggression undertaken by one belligerent side in violation of a basic international obligation prohibiting recourse to war as an instrument of national policy. In the Nuremberg trials, whatever may be the cause of a war that has broken out, and whether or not the cause be so-called just cause, the same rules of international law are valid as to what must not be done and what may be done. Now, sources of international law. Sources of international law are treaties, right, which are agreements between states, evidenced by a document called a treaty, right, that stipulates certain things. That's international law between states. International law also includes customary international law. Customary is where every state, not some, every state accepts conduct as law. So the principle or the customary international law of, in the 19th century, diplomatic immunity. You don't need a treaty to say that was customarily understood, right? But later in 1969, the Vienna Convention on Diplomatic and Treaties, I think, treaties and diplomatic relations, that's where they codified customary international law, not create new law. So what was the customary international law in 1893 when the Hawaiian government was illegally overthrown? That law was an obligation where the occupier who overthrew the government must administer the laws of the occupied state. That's what they're supposed to do. Okay. Now that customary law was later codified in 1899, called the Hague Convention of 1899. And then it was superseded by the 1907 Hague Convention, okay, where it now has Article 43, which requires the occupier to administer the laws of the occupied state. I've heard many people tell me, oh, but 1899 came after 1893. No, that's not how international law works, because you have to understand what is customary and then what was codified. And the United States, in its position, like all other countries, have said that the law of 1899 was the law prior to that. It's just codified. So, Article 43 of the Hague Convention. Article 43 does not confer on the occupying power any sovereignty over the occupied territory. The occupant may therefore not extend its own legislation over the occupied territory, nor act as a sovereign legislator. So it's going back to what is international law. And the expression laws in force in the country in Article 43 refers not only to laws in the strict sense of the word, but also to the Constitution, decrees, ordinances, court precedents, as well as administrative regulations and executive orders. There is more to Hawaiian law than just what is in the statute book. You got Hawaiian Kingdom Supreme Court cases, right? You got other cases called Hawaiian customary law as well. You got the Great Maile, right? Which wasn't a law, but that was an administrative process, right? So there's so many things of Hawaiian Kingdom law. It's not just what you read in the statutes. And here we have an indictment during Nuremberg against Nazis, war crimes, Germanization of occupied territories. In certain occupied territories purportedly annexed. Notice how they use the word purportedly, because supposedly they annexed Luxembourg, but there was no treaty between Luxembourg and Germany. Germany just said, we got you, and it's ours, and started to impose German law in Luxembourg. Pursuant to a plan, endeavored to assimilate those territories politically, culturally, socially, and economically into the German Reich. The defendants endeavored to obliterate the former national character of these territories. Basically, that's what America did to Hawaii after they took over in 1900. They obliterated the national character, the national consciousness of our people knowing the Hawaiian Kingdom. That's why we don't know anything today. And we have to accept the fact that maybe we don't know nothing in order to learn something, right? So what is the law of land warfare? Well, this is U.S. Army Field Manual 27-10. So it regulates the laws of war. If you're in the military, if you're in Iraq, you got that handbook, right? You walk around with it. So that's the law of war, law of land warfare. Well, remember the state of Hawaii? The state of Hawaii cannot be a government because it is neither de facto nor de jure. It was established by U.S. Congress, which is limited to U.S. territory. But we cannot deny the existence of the state of Hawaii as a fact, but it is not a government. There is no source of authority other than the U.S. Congress. Make sense? And that's why, again, we go back to the Supreme Court decision. Whatever its origins, we are the lawful government. Okay? Well, it's actually an armed force, right? Remember when President Cleveland said that it was recognized by our diplomat? The U.S. diplomat, John Stevens, created the provisional government. He didn't create a government because President Cleveland said it was neither de facto nor de jure. What he created was an armed force that was carrying out the directives of the United States through him. Does that make sense? And under Article 2 of the Geneva, of the Hague Regulations, it is an armed force. So you can be an armed force during a state of war. I'll give you an example of another armed force of Russia, a Russian armed force in Ukraine. Okay, so the eastern border of Ukraine, they're fighting within Ukrainian territory. And who's in there fighting against the Ukrainian government? Those who have the support of Russia. They're providing weaponry, There's an organization, right? They're not a government, but they're fighting to be one. They're insurrectionary. They're insurrectionists. It's an insurgency. Make sense? Well, that's exactly what was done in 1893. That is an insurgency that was created. That's an armed force. And Article 64, qualifications of members of militias and voluntary corps, which are called armed forces. They must have a command by a responsible person. There must be fixed, distinctive signs. They must carry arms openly, and they must be able to comply with the laws of war. That pretty much regulates an armed force, not an armed government. And in Chapter 8, remedies for violation of international law, called war crimes. Section 499, war crimes. The term war crime is the technical expression for a violation of the law of war by any person or persons, military or civilian. Every violation of the law of war is a war crime. Okay? Section 500, conspiracy, incitement, attempts, and complicity. Conspiracy and attempts, to, as well as complicity, in the commission of war crimes are punishable. So that's straight up laws of war. On January 17, 1893, the Hawaiian Kingdom came under belligerent occupation. That's a given. That's not debatable. The law of occupation mandates the occupier to administer the laws of the occupied state. The United States didn't do that. Because they didn't do that does not mean the law doesn't exist. It just shows it's a violation of the law. According to Judge Crawford of the International Court of Justice, belligerent occupation does not affect the continuity of the state, even when there exists no government claiming to represent the occupied territory. So again, distinguish between the state and the government. So what was overthrown in 1893? Not the state. That's what's key. But if you read the Apology Resolution of 1993, it looks like the whole kingdom was overthrown. Yeah? That's why people say, restore the kingdom. How do you restore something that already exists? So the Hawaiian state, Hawaiian Kingdom as a state, established in 1843, November 28th, is its national holiday called Independence Day, La Kuokoa. That state sovereignty of the Hawaiian Kingdom had a government called the Hawaiian Kingdom government that exercised its authority. It was illegally overthrown by the United States in 1893, but it did not overthrow the state. And the law of occupation is what kicks in, whether we know it or not. It is automatic. That's the law of occupation. Okay. So, Lance Larson versus Hawaiian Kingdom. What we have here is the state. So before this court could even accept a dispute between Lance Larson, a Hawaiian subject, and the Hawaiian Kingdom by its Council of Regency, a restored government, they had to make sure that the Hawaiian Kingdom existed as a state, not trying to become a state. It had to be a state. And it had to have something representing it to speak on its behalf, and that would be the Council of Regency. Well, the Permanent Court of Arbitration exercises institutional jurisdiction where they have to verify that at least one of the parties is a state. So there's a dispute between two states before they form a tribunal to resolve the dispute. In this case, Ecuador versus United States. It identified Ecuador as a state, United States as a state. Then it formed the tribunal, and then it went toward dispute resolution. It could also hear disputes between a state and an international organization. This is between Peru and the United Nations. They identified Peru as a state and the United Nations as an international organization. And then for the Lance Larson versus Hawaiian Kingdom, this is between a state and a private entity. Lance Paul Larson, a private entity, the Hawaiian Kingdom, a state. So what's profound here is, didn't they also say the United States was a state in the Ecuador arbitration? But nobody understood the significance of this because back then nobody understood in Hawaii the difference between a state and a government, right? I remember coming home from The Hague and I'm trying to explain it to some people and they're trying to tell me, no, that's not what happened. And I'm going, really? How do you know that? No, I know, because I read a book. Oh, brother, I was there. And you know what? I said, I got to get into University of Hawaii. We're going to start educating. And we're going to do the real education. It's called get a degree. We're going to start writing law review articles. It's going to be challenged, right? It's not going to be professing anything. And sure enough, that education that we initiated back in the year 2001, today we're reaping the benefits because people now are being educated because they're coming through the university, they're coming through the schools, teachers are coming through learning. So that's what was important. We needed to address the denationalization that America did to us through the schools since 1900. We got to address it with education as well. We're countering it with the right information. Okay. And that's me representing the Hawaiian Kingdom government. Then we also have in 2018, the Human Rights Council. We have this guy, Dr. Desaias. He issued this memorandum addressed to the members of the judiciary of the state of Hawaii and two judges. This is in response to a complaint written or submitted to the Human Rights Council by Ruth Borome. Now what Desaias is referring here is nothing new, right? This is what has been a part of our educational aspect from the beginning, right? Article 43, it's in the dissertation. It's actually in the Larson case. If you folks read the pleadings, it's all there. Article 43 mandates the occupier to administer the laws of the occupied state. The whole dispute stemmed from the imposition of American laws, which led to Lance Larson's incarceration and his jail time. That was the whole case. After that case, we came home, we got to start educating. And education and education and education. Well, I think an indication of education must have affected this guy, right? So he writes, as a professor of international law, the former secretary of the United Nations Human Rights Committee, and the author of this book, and now serving as the UN independent expert, I have come to understand. Think about that. I have come to understand. He's implying he didn't know it before. I have come to understand that the lawful political status of the Hawaiian Islands is that of a sovereign nation state in continuity. See, now people who know the difference between a state and a government, that makes perfect sense, right? But a nation state that is under a strange form of occupation by the United States. The reason why it's strange, because international law says you're supposed to administer the laws of the occupied state. What's strange about this is they're not. You got an entire foreign system in this nation state that still exists. That's why he's calling it a strange form of occupation, resulting from an illegal military occupation and a fraudulent annexation. This is good because the United Nations is saying that. Not like he's bringing in anything new. What he's doing is he is citing what is the law, whether it's Hawaii or any other country under occupation. That's what he's saying. And then he goes on to say, as such, international law, which is the Hague and Geneva Conventions, require that governance and legal matters within occupied territory of the Hawaiian Islands must be administered by the application of the laws of the occupied state. In this case, the Hawaiian Kingdom. I'm so glad he didn't say the Kingdom of Hawaii, because he's going back to what it was before 1893. Because if he said Kingdom of Hawaii, that's an indication he's looking at the apology. Not the domestic laws of the occupier, the United States. That's important, right? I've been in communication with Dr. Desaias in Switzerland, with a few Skype meetings. This is legit, he did it. That's his memorandum. And the scope of his authority as the UN independent expert, that is part of what is called a special mechanism within the UN Human Rights Council. When he speaks, the UN speaks, whether you like it or not. Whether the country on the receiving end likes it or not. The UN is speaking because he's speaking from a position of an authoritative position. He was elected in 2012 by the Human Rights Council to that position, and it included the United States in the Human Rights Council. I don't know specifically they voted for him, but he was voted in while they were serving as a member of the Human Rights Council. Now, he also makes reference to the word plundering. Plundering is another word for pillaging. Now, when he cites the Hague and Geneva Conventions, he is not citing human rights treaties like the International Covenant on Civil and Political Rights, which Article 14 says all people have a right to a fair trial. He's citing the Hague and Geneva Conventions, which you cite during a state of war. And the right to a fair trial that you would normally have as a human right under the International Covenant on Civil and Political Rights, you actually have it under Article 147 of the Geneva Convention. That you cannot deprive a protected person of a fair and regular trial. So again, you got to separate the two, right? What state of affair are you in? So he's saying that you're supposed to administer the laws of the occupied state. What if you don't administer the laws of the occupied state according to the Hague and Geneva Conventions? Remember the term war crimes? That's what it is. Violation of the provisions of the Hague and Geneva Convention are war crimes. So he uses the word, the ongoing plundering of Hawaiian lands. That plundering is important. That's a term associated with pillaging. And then he also uses the words enable and collude. Therefore, the courts of the state of Hawaii must not enable or collude in the wrongful taking of private lands. Remember that Kaulia case? That Supreme Court and the other courts are colluding. There's a conspiracy to deny the rights of people. Foreclosures, all that. That's plundering. That's pillaging, because you cannot touch private property under the laws of occupation. Now you could foreclose on the property if what? When can the occupier have a system that could do foreclosures? On one condition.
Administering Hawaiian law.
Exactly, because you could foreclose on the Hawaiian law. You had mortgages in the Hawaiian kingdom too. You had foreclosures. The problem is you can't do it under American law, because that's a direct violation of the Hague and Geneva Conventions. Make sense? So when we look at the state of Hawaii as an entity, we're all starting to come to that realization that it's not what we thought it was. And now we're getting into situations where it's an existential threat, a threat to the state of Hawaii's existence. Because this information speaks to that. And that's why state of Hawaii officials are getting very, very nervous. The problem is state of Hawaii officials are stepping into the same shoes as their predecessor, the insurgents. That's the problem, because now that's my cousin over there, pillaging. That's me getting paid by the state of Hawaii from pillage monies through so-called taxation when I work at the University of Hawaii. See, we're all caught in this. What you don't want to do is try to defend yourself in it. The best thing to do is, I didn't know. Because these are war crimes. And we have to be careful how that's played out. So if you want to get more information, you can go to hawaiiankingdom.org blog, and a lot of information there. So with that, question and answers. 5 minutes? A little over 8 o'clock. Yeah. Yes.
Okay. La Hoi Hoi Ea was just over. So that was an insurgent situation but not with the state of Britain, or was it with the state of Britain?
No, that was just a takeover by a British naval officer who took over, and how he justified that was he was saying, you folks are not British, you're not acting British anymore. I got to take over. Because see, the Hawaiian Kingdom was actually part of the British Empire, it was a protector. And that La Hoi Hoi Ea was only the restoring, not of sovereignty, the restoring of the government. It was Kauikeauli's government that was suspended or put into abeyance under protest and replaced by Lord Paulette to run everything.
So did he yield?
Yeah, he did. And that's why the Queen, in her yielding of authority, she actually took it from the experience of what happened in 1843, 50 years earlier.
But he yielded to Britain.
To investigate and to determine what's going on, because his condition was, my envoys are securing the recognition of my independence. So his yielding of authority was conditional on the outcome of his envoys. Queen Lili'uokalani, her yielding of authority was conditional on the president doing the investigation and then reinstating her. Yeah. Yes.
You know, in the determination from the Permanent Court of Arbitration, where it said that in the 19th century the Hawaiian Kingdom existed as an independent sovereign state, and then it did the conclusion of the third party necessity for attendance. However, am I correct in assuming that because they heard you, that they heard your arguments before them in the year 2000, that they were saying tacitly that that the Kingdom of Hawaii still exists, even though in their determination they sort of backed off and said, well, it existed during the 19th century, but because of the United States, what's not said, we don't want to say that it still exists. Do you see what I'm saying?
Okay. No. Because you're conflating the dispute itself with the jurisdiction of the Permanent Court of Arbitration.
Oh, I see.
So you might say the Hawaiian Kingdom won through the Permanent Court of Arbitration's acceptance of the case because it verified the Hawaiian Kingdom exists as a state.
But they didn't say that in the determination. They just
the
said
determination was whether or not the Hawaiian Kingdom was liable to Lance Larson for not protecting him from the imposition of American laws. That was the dispute. The dispute was not whether or not the kingdom exists.
Well, no, I'm not denying that. I'm just wondering why they just didn't go that one little step further and say, well, the Hawaiian Kingdom existed as an independent sovereign state in the 19th century till now, but because America won't participate, we can't make any ruling.
That's what they said.
Oh, well,
that's precisely what they said when you
well,
read the
yeah,
award.
I didn't. When I read it, I didn't see that.
Even Steve back there, he's an attorney. He said, no, that's what they said.
You said it better than they did.
No, exactly. That was the case.
Yeah.
See, the key here was the indispensable third party was not on whether the Hawaiian Kingdom exists as a state. Remember, we're past that. This came out of the train station, and it's in the arbitration, right? It already came out of the permanent court where they formed the tribunal. You can't even get to the tribunal without being a state.
Right.
Because it has to be an international dispute, okay? So when it was not with when the dispute, jurisdiction on the dispute was whether or not Lance Larson can sue the acting government without the United States participation. Now, when I went to Washington, D.C. to invite the United States, upon the recommendation of the Secretary General, to provide a formal invitation for them to join in the arbitration, that wasn't about whether or not the kingdom exists, but we offer an invitation for you to join in the arbitration to explain how you can impose American law.
Right.
Yeah, that's what it was. Now, naturally, what are you going to do if you cannot justify your imposition of American law when the whole thing's illegal?
You don't attend.
You don't attend. And then they asked permission from the Hawaiian government if they could have access to the records. And that was an agreement that was brokered between the State Department through its embassy in The Hague and the Council of Regency that I represented, and who brokered it was the Secretary General, Deputy Secretary General of the court, which allowed the United States to access the records. No.
Yeah, a couple points, yeah. So even if the Senate had accepted the joint resolution of the Treaty of Annexation, the presenting government for Hawaii was neither de jure or
Exactly. There was an
so even
insurgency.
if they did it, would have been not effective. And the second thing is that
that's true.
since there is no Hawaiian government de jure or de facto today, they have no ability to annex the place today.
Well, the thing is, the law of occupation prevents you from annexing occupied territory. That's one of the rules. You can't. Even if you had a government called a government in exile or an acting government, you can't annex it. Period. It's prohibited. Especially when you are illegally occupying a foreign state.
Care to comment on the attempted trademarking of Aloha Poke?
Well, let's bring that up. What's at the heart of that issue?
Money.
No?
American commercial law.
Commercial law, trademark, right? So the trademark law is American, right? So where does American law apply?
In America.
Right. So if anybody is going to be in California establishing a business with that name, they run into the trademark law. That's an infringement in the American system. But it wouldn't apply in Hawaii. Right? Because the trademark law is no different than the commercial code, the constitution, the statutes, and everything else. The Hawaiian Kingdom law on trademark would apply. And there actually is a law on trademarks in the civil code.
So the trademarking would apply in Alaska.
Absolutely, exactly.
So those guys, yeah,
They gotta
got
comply
challenged.
with trademark law, right?
Yeah.
Yeah.
And there's an international agreement that the United States has with other countries in regards to copyright and trademark.
Yeah, and that brings it in, yeah, so that's the
It does,
interplay
because
between the
you
two
pay-
countries.
You pay extra for that with the US to have that extra protection on the international level.
Okay, no, there you go. And that's a distinction between what is international law and municipal law.
But then you would look back to the Hawaiian Kingdom, to their civil copyright trademarks
Whatever
back then.
Hawaiian
And
law
whatever
is.
it was agreed then would still be in play today. for
Absolutely,
that.
and that's the laws that Desai said must be administered, not U.S. domestic law. So the point that if somebody says, hey, they're applying the U.S. trade law on aloha poke in Hawaii, somebody can say, hey, that's a direct violation of Article 43, the Hague Convention.
Question. That would also go with the Denny Wong court case where he was suing jewelers in the state of Hawaii for copy trademark he got for plumeria designs of jewelry in the 80s and 90s.
All the copyright laws
Because it
since
goes back to
1893 are
Connie
illegal.
in the 1800s as a flower used in jewelry.
Yeah, anything, because everything after 1893 was illegal. Yeah. Because they should have administered Hawaiian Kingdom law. Yeah. Yes.
I got a question. I don't know if it's according to this bill, but part of it is a Kauai, right?
Okay.
They used to work for the Robinson.
Okay.
Are they part of the kingdom or is that?
Yeah. No,
like
that-
part- how did they apply pass through not being part of the state, I guess?
but actually, state law applies there.
Excuse me?
State law applies there.
Applies to them?
Yeah, but but the way they interpret the law is by an agreement, more private agreement between the family that supposedly owns the property of Niihau, as opposed to having Niihau being a sovereign state.
So it's still
Yeah, it's still part of,
part of the kingdom?
yeah, just like all the rest of the islands are, but everybody thinks it's under the United States.
But it's not.
Yeah, yeah, yeah. Now, one thing I wanted to pull up here, okay? This is an indication of how the courts feel. And this goes to State of Hawaii versus Kaulia, okay? So this is a court case in 2012. Dexter Kayama is representing a defendant in a foreclosure case, and he submitted a motion, he's arguing a motion to dismiss based upon State of Hawaii versus Lorenzo and Ishitani versus Baker. And the evidence that Hawaiian Kingdom exists as a state. He cites the Larson case, he's citing the limitation of a joint resolution, he's citing the Hague Convention, he's even citing Article 43 of the Hague Convention. So, this is what Judge Hara from the Third Circuit says on the record. He shouldn't have said it on the record. So this is Judge Howard. In my mind, Mr. Kayama, what you're asking the court to do is to commit suicide. Because once I adopt your argument, I have no jurisdiction over anything. Not only these kinds of cases where you may claim either being a part or being the citizen of the kingdom, but jurisdiction of the courts evaporate. All of the courts across the state, from the Supreme Court down, we have no judiciary. I can't do that. He said that in open mic. That's in the transcripts. That is the knee-jerk reaction you get from State of Hawaii officials when somebody is trying to follow the law. Yeah? And by him doing this, he just admitted that he knows about Hawaii's occupation. But he's going to be committing political suicide. What you just did is one of the elements of a war crime is awareness. And this defendant that Dexter was representing is a Japanese, Elaine Kawasaki. She was removed from her home, evicted, by a court that doesn't have any jurisdiction. That is plundering. That's a war crime. And Judge Howard admitted it. That is not a justification to commit a crime. You still have a victim. And that's where the Hague and Geneva Conventions apply. So that is an indication of how the Hawaii Supreme Court is looking at it. Whatever its origins, the state of Hawaii is the lawful government. That is not a good position to be in. Not a good position. The ramifications are profound.
You know, what about the state? They're using the bishop of the state to steal all the lands that the bishop of the state doesn't really own.
Everything stopped in 1893. No titles could be transferred since 1893.
So allodial titles still exist?
Okay, that allodial titles, I don't know where that word is coming from. It's not correct. Let me explain. Because I've heard people on the Big Island come up to me and say, I got an allodial patent. Okay. Allodial. There's a difference between allodial, A-L-L-O-D-I-L, A-L, allodial, as opposed to allodio, A-L-O-D-I-O. Okay? So when you look at the Palapalasi Illinois, which is the Hawaiian word for royal patent, it refers to fee simple as Kuleana Nui Makeano Alodio. Alodio is a Hawaiianization of an English word. It is not the English word. And allodio, according to the law, is defined as fee simple. That's all it is. It's in the law. Fee simple, in the kingdom.
But it doesn't say that in Maile book.
No, it actually says, I got the books on that. It actually has the definition of allodio. It says, allodio is fee simple. Okay, it doesn't belong to a sovereign, which is what the allodial term used in Black's Law Dictionary. That's from feudal England. Okay, that's part of the feudal system. And everybody beneath the person with the allodial has fiefs or fiefs, which eventually came to be known as fees, becoming fee simple, right? Whether fee tail, fee simple, life estates, whatever the case may be. So then you have the word kuleana nui malalo iho poke ano allodio. Less than allodial. Less than allodial, by definition, is a life estate in Hawaiian law. So that's the terms. So when you have a fee simple title in the kingdom, a fee simple title is not ownership of land. Fee simple or lease or life estate is ownership of the control of the land, not ownership of the land. Who owns the land is the state. Right? What happens if you don't pay your taxes on your title? They can condemn it. They can foreclose on it. Right? What happens if there's going to be a railroad coming through your property? It will exercise eminent domain. Domain is ownership. Eminent comes from the word eminency, a higher ownership. Now, in a constitutional system, if you're going to exercise eminent domain and higher title, you got to compensate, right? But if you live in a communist country, you don't have to compensate. It's called nationalized. That's what Cuba was doing. But that is an exercise of eminent domain, where one, you compensate, the other says, no, we take it on behalf of the state, the control. So that's part of, when I say Hawaiian Kingdom law, that's also part of Hawaiian Kingdom law. All the different ordinances and everything, not just, like you might say, the Maile book. Because the royal patents are not from the Maile book. They're actually from the Interior Department. And it's in the records of the Interior Department that allodio is fee simple. And less than allodio is life estate.
So if you got the ancestors' names, can the people still claim that land?
Absolutely. If you're an heir, absolutely, you have heirship rights. Yeah, absolutely. And it's inherited rights under Hawaiian law, which is very similar to heirship rights under American law. right? But actually in the Hawaiian Civil Code, you will find, look in the index, you'll find heirship. It'll tell you how how heirs can acquire property, interest in property, which creates what is called tenancy in common, undivided interest, not necessarily just coming to one. So it can get very complex as far as inheritance. But with regard to the occupation of Hawaii, the person who held a royal patent, right, and he did not transfer that property by deed recorded in the Bureau of Conveyances before 1893, then it would still be in the family today, right? But the inheritance or rights to heirship has to be under Hawaiian Kingdom law, not under American law. There's a distinction there. Yeah. But any property conveyed after 1893, January 17th, is void because it was all done not under Hawaiian Kingdom law. Take a deed recorded in the Bureau of Conveyances, January 18th, 1893. Look at the notary. That notary is not a valid notary. That notary is an insurgent. That means that deed was not properly acknowledged. And Thomas Thrum, Thrum's Annual, he was a registrar of the Bureau of Conveyances in 1893. He was an insurgent. So he could not record. So that's why all titles stopped in 1893. So if we get back to Zais' memorandum, he even states that adjudication of land titles and transactions have to be under Hawaiian Kingdom law. So he's talking quiet title, foreclosure. So anything that happened after 1893 actually never happened. Yeah. Yes.
How can we keep these entities accountable for all the stuff they're doing now?
That's where we have to just get into continued education, because we need to know what we're talking about and not expect somebody else to do something that I don't know what they're supposed to do.
Right.
So there are things that are happening though, right? So I'm not just going around giving talks and teaching. There's a lot of things happening that deal with these very difficult and complex issues. This is not something you just can walk right in. Yeah, I got them. My doctoral dissertation had to break this thing down, because my doctoral committee asked me, Keanu, how do you fix the problem? Because they began to then see the problem. And so I'm glad you asked the question, because before that, you didn't think we had a problem. We have a big problem. It is big. And my chapter 5 gets into how do you begin to right the wrong. So first of all, we need to understand, we have to be educated on what is the law of occupation, what are war crimes, more importantly, what are Hawaiian Kingdom laws, and what is Hawaii's history. Those are that's foundational. And not that we need to try to figure out how to fix this problem. No, we can only fix the problem if you understand the problem. And to understand the problem, it gets very complex. But what can I do now? I need to learn. I need to get educated. And it's an ongoing process. Education never stops. I keep learning as well, right? So that's what's important. Yeah. Tonight, I'm not trying to get anybody to do anything. I'm just here to explain to you why the state of Hawaii is an armed force.
Well, one more question in Monica. Where can I get these things, or are you writing a book that we can learn from, or all of these 10,000 questions that I like to be educated so that I can even talk to younger people?
In the Huelo Island?
I'm all over the place.
No, well, are you in one of the groups?
Join.
Oh, okay. So I would say purchase my book, Ua Maukea, which we used at the college, that covers Hawaii's legal and political history from Kamehameha, 1780s, all the way till today. Has a glossary, and that book is required. So it is dense with information. It is a watered down version of my doctoral dissertation. Okay, but it is right now the history book at the Kamehameha schools. That's the history book. It is the book that we use at the university. I would recommend go get the book and just start reading. It's like a history book, but it has all these legalities, but it doesn't cover everything. But I believe it covers enough to begin to understand. And then there's more resources out there. Yeah.
Well, at least that's the beginning of the trail, I think.
At least that's the beginning.
Thank you.
Right on, mahalo. And with that, I'm going to bring it to a close. I want to thank you guys for this presentation.